When you go to court, the courtroom will look similar to the one you see in this video. When the judge comes into the courtroom, everyone will stand up. You may have to wait for your hearing to start. When the case is called, you should say present and then move to the front of the courtroom as directed. To start the case, each side may make an opening statement, but one is not required. The opening statement is not the time to give testimony or to argue your case. It is a time to give a brief summary to let the judge know about your case. Let's watch as Jim and Bill make their opening statements.
Your Honor, I was hired by Mr. Dell to fix a leak in his pipe. When I completed my work, I left a bill for $1,000. When he didn't pay it within 15 days, I contacted him and he said to me that he wasn't going to pay it. So I filed this suit.
Thank you, Your Honor. It is correct that Mr. Raffo did work on my plumbing. However, the day after he left, a leak developed in the pipe that he replaced, which caused my kitchen to flood and my flooring to be damaged. It cost me $1,000 to hire another plumber and another $3,000 to replace my flooring. I feel that I don't owe him anything. Actually, I feel he owes me for the damage to my floor.
Note that Jim and Bill both gave brief opening statements that explain what their case is about. After the opening statements, Jim presented his case. All witnesses, including the parties, will be sworn in on their oath or affirmation by the judge or the court clerk before they give testimony. Now let's watch as Bill presents some of his evidence.
Your Honor, I would like to introduce as evidence a photograph that I took of my kitchen the day after Mr. Raffo worked on my plumbing this past March 15th.
Please approach the bench. Thank you. I will mark this as Exhibit A.
This photograph shows the damage that occurred shortly after Mr. Raffo supposedly worked on the pipe. I also have a copy of the bill for the repair job that the second plumber had to do, Mr. Groff.
Please approach the bench, and I will mark this as Exhibit B.
Thank you. I would like to call Mr. Groff to testify.
Do you swear that the testimony you will provide to the court today will be the truth and nothing but the truth, so help you God?
I do.
Thank you.
Mr. Groff, what is your profession, sir?
I own my own plumbing business.
And how long have you been in the plumbing business?
25 years.
And where did you obtain your training?
I completed the plumbing training program at Dell Tech and also an apprenticeship.
And what was your opinion of the repair job done by Mr. Raffo?
It was totally inadequate. He connected the new pipe to the existing pipe, creating a major leak, and I had to replace the new pipe.
Tell me, do you recognize this document?
Yes, that's the repair bill I sent you for the work that I did.
Thank you.
Bill did a good job of presenting his evidence to the court. He had three types of evidence: demonstrative, the photo of his kitchen; documentary, the bill from his second plumber; and testimony. He showed that his plumber was an expert witness who was qualified to offer an opinion on the quality of work done by his first plumber. After each witness testifies, Jim will be given a chance to ask questions about their testimony, that is, to cross-examine the witnesses. When both sides are finished presenting their cases, each side may, but is not required to, make a closing argument. This is a time to summarize the evidence that was presented during the trial, to explain why the evidence that was presented supports your claim and why the judge should rule in your favor, or why the evidence presented by the other party does not support their claim. After all the evidence is presented and closing arguments, if any, are made, the judge may make a ruling or may wait until later to mail his or her decision. Now let's turn to Maureen. She has been preparing her case to change the previously established child custody arrangement with her ex-husband. As we have seen, Maureen has visited the Family Court Resource Center in her county, where she obtained the forms necessary to file her case. She is now thinking about the evidence that she needs to present and has decided that she will ask her ex-husband's neighbor to testify that she has received calls from the children at night asking her to come over because they were afraid of being alone, and that she has gone over and sat with them until Ron arrived several hours later. Since the neighbor seems undecided as to whether she really wants to come to court to testify against Ron, Maureen has asked the court for a subpoena to require the neighbor to come to court. Keep in mind that police reports are not evidence. For example, if Maureen had called the police because her ex-husband was leaving the children alone, she could not introduce the police report as evidence. This is particularly important for anyone to know who is going to family court to obtain a protection from abuse order. Most people are nervous about going to court. Let's take a look at a family court courtroom so you will know what to expect. You will be sitting at the table in the front and may be seated near your ex, which can be emotionally difficult. Some family court judges will ask you a lot of questions, while others may expect you to take the lead in presenting your case. As you saw with Bill, you will need to present your evidence. The petitioner will go first and will present any of the types of evidence the petitioner has. Then the respondent will have a chance. Once both sides are finished presenting their evidence, the judge may rule or need time to make a decision, in which case you will receive the decision in the mail. I hope this video has helped you to understand the system better. Let's review the basic steps in a lawsuit. First, you start with a written statement of your side of the case called a complaint or petition. This must be delivered to the other side. The defendant or respondent is given time to file an answer, which must be served on the plaintiff or petitioner. Then each side prepares for the hearing. At the hearing, each side can present evidence, including witnesses, documents, photographs, etc., to prove their case, and then each side can cross-examine the other side's witnesses. The case concludes with the decision by the judge, either at the hearing or at a later time.
The Delaware Supreme Court's Fairness for All Task Force hopes that this video has given you a better understanding of the steps involved in a lawsuit, should you choose to represent yourself. You can find more information on each of the court's websites found at courts.delaware.gov, and for family court by visiting the Resource Center in your county. You can also find information on the Legal Services Corporation of Delaware website. However, you should be aware that while some cases, particularly in the Justice of the Peace Court, may lend themselves to a do-it-yourself approach, other cases are more complicated, and it may be best to have a lawyer if you can afford one, or find a lawyer to represent you at little or no cost. Keep in mind that you can involve a lawyer at any stage in your case, should you change your mind about being self-represented. On behalf of the task force, I would like to thank you for watching. I hope this video has been helpful.